there, and welcome to Intangify, where we discuss the intangible aspects of business. Today, I'm Matthew Asbell, I'm your host, and today we're going to talk about something pretty close to home for me. As some of you know, I'm an intellectual property attorney, and we're going to talk a little bit about patents, but patents particularly for entrepreneurs. And my guest today is Chintan Desai. Chintan Desai and I work together at Offit Kerman, the law firm. We're in the New York City office of a general practice law firm, and regularly work on patent matters. We're having these discussions all the time with our clients. But we thought it would be useful to share the kind of information that entrepreneurs want to know about patents, over the podcast. So Chintan, welcome.
Thank you for having me on, Matthew.
Glad to have you here. So I think maybe to start off, maybe you could give a little introduction about yourself. Tell us a little about your background and your experience.
Sure. So I'd be remiss to say if I've always wanted to be an IP lawyer from the very beginning, but I kind of, gravitated into it. I started off pre-med, was bioengineering undergrad, and then I enjoyed the engineering aspect, but I hit organic chemistry and I said, all right, I'm okay. So then I just continued forward, took a bunch of legal studies courses as electives, and just really gravitated towards the law. And then, normally you'd think this is where you go to law school and then, continue. Nope, no. I actually then worked on an EJ grant, which is an environmental justice grant. Basically, think Aaron Brockovich, but the clinical side of it. There was a chemical being released in the groundwater. Not going to name specific names of companies, but you can infer. There was a study and I came on at the right time. And so I essentially, right after graduation, I continued, started as a work study job, then became a clinical research study coordinator job. So I was at the University School of Medicine at the University of Pennsylvania, just doing that, following it through. And essentially it ended up being published in like 4 medical journals, talking about the importance of community stakeholders and bringing people to the table. And again, this all leads right back into, I should go to med school. But that being said, after, I had gone through that process, and I think it was helpful because I think post-undergrad, always think like, all right, this is what you should do. And this is what it should be like. But I think it's important to be able to explore and get an idea of what you really want to do. And I think you can't really substitute that experience. So at least that's what I'm telling myself. So then eventually I, after the grant ran dry and I was like, well, you know what, now back to what I kind of enjoy doing. And so I then said, all right, I'm going to take the LSAT, went to law school. And lo and behold, I actually started taking some environmental law classes even then. And it kind of came full circle because at times I was working with people that I'd worked with on the public policy side, but now they were on the other side of the table as an attorney. So that all being said, I then, kind of gravitated again towards some of the IP courses, and it kind of just resonated with me. And so post law school, I started at a boutique firm. And one of the things I really enjoyed is I was able to get immersed into all aspects of intellectual property law. So that's patent, copyright, trademark, trade secret, and all related litigation, enforcement, everything, basically from, the prosecution side, procurement side, and then all the way through the process. And I think that was a rare experience as a young associate because we were in a smaller firm. But that's one of the things I really enjoyed. So I got to really, get experience in a lot of different things from people that had been at previous big firms. So fast forward, I was in this previous firm for about 5.5, 6 years almost. And then I came to Offit Kerman and I was blessed to be able to do the same kind of thing. So bigger firm, a lot more ability to cross-sell, but working closely with a smaller number of people where I could focus on different aspects of patents, trademarks, copyright. And I think one of the most valuable things of that is I was able to see the entire process through, because I think it's very important, especially when you're working with clients, to have that ability to guide them through, because you're not just saying, oh, do this. You're actually, advising them, because at the end of the day, the IP has to meet the business needs as well, and they have to work together. But that's
so I can relate to a lot of what you're saying. Of course, as as someone who sort of swerved through life prior to law school myself, and I guess that lends itself well to intellectual property law, where you have all different kinds of creative aspects of things that you're trying to protect. So I definitely can relate to that. But I do want to bring this full circle back to entrepreneurs, and and I know in the context of your work at Offit Kerman, you do a lot of patent work on behalf of usually funded entrepreneurs, but sometimes really, just people just starting out and who are completely out of pocket. And I think since the majority of people listening to this program really are in that ilk, I would like to really chat with you about some of the aspects about patents and whether that's something they even should care about. So maybe to start off in that subject, maybe as a first prompt for you, how do I even know if I have something patentable? What is patentable?
Right. So, it is an open-ended question, but I think one of the things to always remember is sometimes things out there that you visually see may already have been, let's say, disclosed, but not necessarily monetized, right? But I think the only way to really do that is to kind of immerse yourself in it. And, we typically at the outset, recommend doing essentially a patentability search. Now, what that does is helps you identify what the landscape is, what's out there, right? Because at the end of the day, when you want to think about what's patentable, right, it just can't be, let's say, a mathematical formula or something that's just done a little faster, or a law of nature, right? It's got to be something that is, we call new, novel, and non-obvious, right? So novel is it's new, not necessarily released to the public, but non-obvious. So for example, if you see something out there, it's got to be something significantly more than just what you see. Or to the layperson I say, to someone skilled in the art, they look at that, what your invention is that different from what's out there? And I think,
let me interrupt you there, because I think when you have a client who comes to you who's an entrepreneur and they're thinking they want to get a patent, they'll come to you and they'll talk to you about that, and this is part of the conversation you'll have. But I'm thinking before then, what's going to prompt them to come to you in the first place? The ones who are going to come to you in the first place, they're thinking, they need some sort of prompt or cue if they're not used to the process of creating innovations and inventions that are patentable. They need something to trigger them that, maybe this is something that I should consider getting a patent on. And so I want to get at that. How do they get there? Yes, of course, once they come to you, you're going to tell them we should do a search. But what should be the prompt of, do I think this could be something that would be patentable innovation that I could own? That so much so that I should talk to an attorney? What's the prompt?
so I think it's kind of intertwined with what you normally do in a business, right? You're filling a need, something that's not out there, right? So whether it be a product or a service that your business is involved in, you're going to try to find your niche, or you're going to find your specific carve out, right? And part of that on the business side is identifying what's not out there, right? Or if something's out there, I know I can do it better. And that's why my product or my service, that's why you're going to come to my company or my business to do that. And I think it's important to, see that difference and then take that to the next level, right? So just like in business, if you see, a gap in the market or something that you think that, all right, my services or my product, this will solve a problem there. I think the moment you have that light bulb on the business side, that is also when you should be thinking about the patent side and even other related, IP. But that should be your at least initial trigger, because at the end of the day, is this different from what you've seen, and what are you trying to solve, right? And if you believe others aren't solving this and you believe this product does it, that is when that conversation should definitely start. And you should think about, all right, I'm the only one that does it. Now I want to do it, but I also want to make sure that others don't copy me. And that's where, the two things really coalesce.
So what I'm hearing from you is whenever someone innovates, now that doesn't necessarily mean that they've got something that they could get a patent on or that they should, but that's the prompt. They've innovated, and they think their innovation is an advance over what they know exists. So now they want to explore that, and they see the value of having exclusivity in that one way or the other. So how revolutionary does it need to be? This, how much of an advance, do I need to have to decide that, gee, maybe this is something worth patenting?
So I think it really does depend on the technology, but there's no one rubric that says, okay, this is, different enough, right? I think it is really a sliding scale, right? So, if you take, let's say, for example, software, it's murky. What is different? How different is it? And I think it's something where it's the difference in, a part of that process is how different is it, right? Or why don't other products solve this, right? And the more reasons you have where other products don't do this, or not only does my product do, this better than, let's say reason 1, but also reason 2 and reason 3. So now when you start thinking about that, those are your cues to say, all right, maybe it doesn't have to be revolutionary. It could be any simple, it could be day-to-day item, or it could be a service that necessarily hasn't been thought about. But more often than not, you'll find that a lot of patents build on, existing technology, right? Because as you see innovation, as you see business growing, people think, all right, these are different needs that I want to solve. And I think more often than not, they build on those core ideas. So you want to start just, there's no, I'd say, barometer for revolutionary. It's just, filling that gap, filling that need, and it will vary based on the industry.
So it doesn't need to be revolutionary, but it needs to be an advance. And you referred to, you said it depends on the industry, and one of the industries you referred to specifically, just almost knocked over my computer there. One of the industries you referred to specifically is software. But software and patenting of software is not just about the advance, right? Okay, fine. I've innovated with some new software. I mean, a lot of people are innovating with software. From a patent perspective, it's got to be more than that, at least today, right?
Yes. So, first, software patents, right? In general, it varies on how they're treated. So, there isn't harmony on how software patents or patent applications are treated, whether how they're examined. And, the main crux of it is, when you look at a software patent, it has to improve computer functionality, and it has to do it, it has to solve a computing challenge in an unconventional way. And that's basically layman's speak for, it has to do more than just obvious. So it can't just, make computations faster, right? And so part of that is not only identifying, does it do more than what's known or unconventional out there, or does it just make something faster, but also the undercore of like how it works, right? And when you write an application, and we'll probably get more into this, you'll see that how you write an application will also be important when you look at software patent applications.
That's great. Thanks so much. We're going to go to break. When we come back, we'll talk maybe about some other forms of patents and maybe the patent application process. You've been listening to Intangify on talkradio.nyc. I'm your host, Matthew Asbell. We're going to break. See you back shortly.
Are you a business owner? Do you want to be a business owner? Do you work with business owners? Hi, I'm Stephen Fry, your small and medium-sized business or SMB guy, and I'm the host of the new show, Always Friday. While I love to have fun on my show, we take those Friday feelings of freedom and clarity to discuss popular topics on the minds of SMBs today. Please join me and my various special guests on Friday at 11 a.m. on talkradio.nyc.
Are you a conscious co-creator? Are you on a quest to raise your vibration and your consciousness? I'm Sam Leibowitz, your conscious consultant, and on my show, The Conscious Consultant Hour, Awakening Humanity, we will touch upon all these topics and more. Listen live at our new time on Thursdays at 12 noon Eastern Time. That's The Conscious Consultant Hour, Awakening Humanity, Thursdays, 12 noon on talkradio.nyc.
Are you on edge? Hey, we live in challenging, edgy times, so let's lean in. I'm Sandra Bargman, the host of The Edge of Every Day, which airs each Monday at 7 p.m. Eastern Time on talkradio.nyc. Tune in live with me and my friends and colleagues as we share stories and perspectives about pushing boundaries and exploring our rough edges. That's The Edge of Every Day on Mondays at 7 p.m. Eastern Time on talkradio.nyc.
You're listening to Talk Radio NYC. Uplift, educate, empower.
Welcome back to Intangify on talkradio.nyc. I'm your host, Matthew Asbell. My guest is Chintan Desai, and we're talking about patents for entrepreneurs. We were talking a bit before the break about how a business knows if they have something that is patentable, even to prompt them to go to an attorney. And we were recognizing that in different technologies, different industries, what is and what is not patentable might vary. We use the example of software, which is something that's been a little bit out of favor in recent years, but something that is still often patentable. The other ones I wanted to talk to you about in terms of some examples, are maybe things like, well, okay, I came up with a new way of doing business, or a new way in which I interact with a device, like the swipe on an iPhone when that came out. Or even a new appearance of something that already exists. So, there's all different kinds of innovations, right? Innovation in the form of something that improves function is one, but how do you deal with a new method of business, a new way of interacting with a device, or a new appearance of something that is known?
So I think it's really a multi-pronged approach, because you'll often see things where, we'll go back to how things, does it improve upon what's, currently there? And part of that is really how many technical solutions it solves, right? And then you also mentioned, like, let's say the look, right? The design. You may want to protect, the aesthetic side of it, and that's really just the way it looks. And more often than not, you'll often have certain products where there'll be different aspects that are, let's say protecting the design side, because it is, you're talking about the ornamentality, and that's really just how something looks, right? And then you say the function, something may work in a different way or build upon, something out there. And I think how to identify which one is right for you is really a question of, is that function going to be building upon what's out there? Does it provide that, does it solve those technical problems, or, in unconventional ways, and even just, build something that isn't out there? But then also recognizing that sometimes it's not just necessarily function, but design. And I think, it's important to oftentimes discuss both, and honestly apply for both at times.
Yeah, I think all too often people take this very surgical approach to how they want, to the protections that they want. They think they need to protect this concept, this functionality, or they, excuse me, I'm about to sneeze. The allergy is about to hit me. It's burning the nose, right? Or they want to protect this functionality, or they want to protect its appearance, but sometimes it's both. All right, there it goes. I'm safe. Yeah, and sometimes it's both, or different aspects that need to be protected, and having a portfolio gives you a toolkit to enforce, right, and to protect yourself and protect your, what it is you're ultimately doing in the marketplace. So that makes a lot of sense.
Yeah, and just to add, I was going to say, just to add to that. So I think there's also, from the business side, there's a lot of reasons why you'd want a patent, right? And sometimes that is because you want to say patent pending, right? Because especially if you're in a smaller industry or very close to an industry, people know who the other, partners are, or the other companies that are operating in that space are. And so sometimes there's just inherent value to be able to say patent pending, right? And so there's sometimes, strategy behind that where you may not, you want to get the patent, or, that's the goal. But if you're not sure, let's say, about the patentability, right? Or it could be something that you're not sure about. Sometimes you have business reasons as to, I want to be able to say patent pending, or I'm still building this, I'm still working on this, it's still, kind of percolating, but in the meantime, I want to say, this is my invention, let's see where it goes. And I think so. Those are a lot of different business factors that kind of weave into why you'd want to, pursue it.
Yeah, that's the other thing that I think I see a lot, which is that, when people come to you for this, with the idea, like they're thinking as to why they need it. It's not that always that clear, and many people don't pursue it because they're thinking why they don't need it. But you've given an example of one reason why people would need it, which is that they want to be able to discourage others by saying patent pending, but there are others, right? Because patents are often the most valuable part of a business ultimately, and the patentee, the person, the company, the entrepreneur is often thinking about the endpoint of getting the patent and the value of getting the patent. And there can be a lot of value in getting the patent, but there are also some values potentially along the way, like you sort of incremental improvements along the way, or like you said, saying patent pending. So I think it's important for people to realize there might be many different reasons why they should consider doing it.
Yeah, and just to add on that, one of the reasons is, like you mentioned, so a lot of the times when you're an entrepreneur or you're a startup, it's almost, you're betting the company on, let's say, this invention or this product, right? This is going to be what your launch is going to be predicated upon. Sure, in your goals, like down the line, you want to have a product line, or you want to have a series of services, or whatever it may be, but this is going to be the launch point, right? So it's all the more important to make sure that you have your, everything lined up, and you're sure about that, because oftentimes your company's success or your ability to grow will be predicated upon this phase and this invention. So, those are one of the key aspects as to why is it important, because the company's, future could be predicated upon that, or its ability to expand will be, inextricably linked to that.
So like, look, maybe we've persuaded people that it's important, and worth doing, and that it's valuable. But if I'm an entrepreneur listening to you, one of the things I'm thinking is, yeah, but come on, how much is this going to cost me? I'm all out of pocket. I've just launched this business. This is a lot of, I assume it's going to cost me a lot of money to get this. And I'd like to hear you address that. But another concept I'd like to think about is, well, why do I have to do this now? It's going to be expensive. It's out of my pocket, And B, what, you're telling me I have to go do this now? Why? Why can't I just do it in a couple of years?
So, the thing about patentability is, and just, pursuing that invention is, we have what we call, in the US at least, is what we call a 1-year grace period, right? And that's from when you put this product on sale, or when you disclose it to the public, you have 1 year from then to file the application. Now, I mentioned that in the US, and the caveat being, some jurisdictions around the world have what we call absolute novelty, which means they don't have a grace period, right? So the reason it's important to think about it early on before you release that product and not wait is you may preclude yourself from getting a patent later on because of your own disclosure, or let's say because it's been disseminated to the public and it's been more than a year. So that disclosure will be cited against you. Now, there are ways to kind of kick the can further down, and with costs and strategies, but it's important to have that mindset early on, because just like when you have, let's say, your brand or your likeness, you put it out there. Once it's out there, it's going to be disseminated, and people will do with it what they want. But at least you can shape the message that wants to go out with. And I think that's the important thing. And again, you will preclude yourself from patentability if you aren't thinking further down the line, because once it's out there, it can be cited against you.
So patents, unlike other forms of intellectual property, have this time constraint. Abroad, meaning you have to do it before you disclose it or sell it or anything like that. And in the US, at least within a year. And after that, you're basically out of luck. So that's the reason why entrepreneurs need to do this sooner. And so you've justified that. But what about my empty pockets? How am I going to pay for this? This is, I assume it's expensive.
Well, so it depends, right? There's ways, like I said, there's strategies on how you can prioritize certain costs, right? So for example, when it comes to patent applications, yes, the entire process, when we talk about what we call a full non-provisional application and going all the way to basically prosecution, which is when you go back and forth with the USPTO, they say, this is the invention, they say something else is out there, and you argue why it's different. And all the way through to that process of grant, that could be many years, and that could be a lot of money. But there are ways to, within the early stages, push that back further or kick the can further down. Because, for example, if you're a business, you may still, there's a variety of reasons. You may still be building on the technology, right? So this is still in the R&D phase, and we still are fleshing it out to see, is this economically viable? Like, is this something we want to pursue on the business side? Two, I want to, place my time right now, but I want to also see, are there others out there, right? And so you're able to, let's say, file, for example, a provisional application, right? Now, I mentioned provisional applications, it's slightly different than a non-provisional. And it allows you to essentially set your place marker, but it's a much lower cost. And so, the goal is, there are ways, just like in business, when you're in the early stages, you are going to prioritize certain aspects, right? So similarly, when you look at an IP portfolio or the initial stage of how you want to pursue protection, there are ways where you can say, all right, I want to protect it in this way, that don't preclude your ability to pursue, the stronger IP protection later down the line.
So if I'm an entrepreneur and I hear words provisional application and non-provisional application, I have no idea what that means. So maybe you could just briefly define those so we understand what we're talking about. And then stick on the fees with me a little bit here, because it's not just about the form or what you're filing, but maybe also about what the costs of each of those things are.
Yeah. So a provisional application is essentially, it's a placeholder. It never gets disclosed, but it essentially, when you file that, you're saying, here's my invention, and it, the contents is what we call the claims, which, define what the invention is, the description and drawings. It's almost like a baby non-provisional application, but by itself, a provisional application will never just mature into a patent or be examined. But what it does is allows you to place your time in line while you're still developing it, or while you want to, if you want to delay essentially your non-provisional application, which I'll mention in a second, is you want to delay while you're getting your ducks in a row, you're deciding on the business side what's important. And then within 1 year of filing that provisional, we have the non-provisional. Now the non-provisional is supposed to build on that provisional, and that's what's going to be examined, disclosed, and open to the public. And so that's when you really are saying, okay, this is my invention, these are the claims, and then that's what you send, let's say, to the patent office, whether it be the US or other jurisdictions. And so that provisional never gets disclosed until, let's say, a non-provisional is filed that claims priority to it. And it's important to file that provisional, because anything you have in that non-provisional that claims priority, you're able to date back to that provisional, right? So we're always thinking about the priority date, right? Because at the end of the day, you want to be able to say, I want to relate back to the earliest possible date, because in the interim, while you're thinking it out, someone may come along and say, I have this idea. And you don't want to essentially shortchange yourself because you're working on it, but someone else independently is working on it. So that's why it's important to kind of think about both of those things.
Thanks for that. We're going to go to break. You've been listening to Intangify on talkradio.nyc. I'm your host, Matthew Asbell. My guest is Chintan Desai. We will be back shortly.
Are you passionate about the conversation around racism? Hi, I'm Reverend Dr. TLC, host of the Dismantle Racism Show, which airs every Thursday at 11 a.m. Eastern on talkradio.nyc. Join me and my amazing guests as we discuss ways to uncover, dismantle, and eradicate racism. That's Thursdays at 11 o'clock a.m. on talkradio.nyc.
In a post-COVID world, you may have many unanswered questions regarding your health. Are you looking to live a healthier lifestyle? Do you have a desire to learn more about mental health and enhance your quality of life? Or do you just want to participate in self-understanding and awareness? I'm Frank R. Harrison, host of Frank About Health, and each Thursday, I will tackle these questions and work to enlighten you. Tune in every Thursday at 5 p.m. on talkradio.nyc, and I will be frank about health to advocate for all of us.
Hey everybody, it's Tommy D, the nonprofit sector connector, coming at you from my attic. Each week here on talkradio.nyc, I host a program, Philanthropy in Focus. Nonprofits impact us each and every day, and it's my focus to help them amplify their message and tell their story. Listen each week at 10 a.m. Eastern Standard Time until 11 a.m. Eastern Standard Time, right here on talkradio.nyc.
You're listening to Talk Radio NYC at www.talkradio.nyc. Now broadcasting 24 hours a day.
Welcome back to Intangify on talkradio.nyc. I'm your host, Matthew Asbell. My guest is Chintan Desai, and we're talking about patents for entrepreneurs. And, we were talking a little bit before the break about sort of these different forms of what are the utility patent applications, the applications that are for, how things work. And that there is this thing called a provisional patent application that is basically a placeholder, but a less expensive and easier way to get something on file while you continue to develop or look for funding, and you can say patent pending in the interim. And we were talking a little bit about, when you're an entrepreneur, if you're just starting out, you're often out of pocket for these costs. So Chintan, I think the next thing I really need you to address for our audience is, what are these costs? And is there, how do I get a discount?
Right. So it is an important cost, right? And I think the reason we think about that is because, early on, certain things like, let's say, the filing costs for, let's say, non-provisionals, those things do add up. So, you're talking about the attorney's fees, which are the constant, but, I'd say we have the most competitive rates. But I digress. But, you have to think about the official filing fees, right? And those things do add up. So there are ways that those fees are reduced, and, they're referred to as entity fees. And, based on the type of entity you are, you may be, be able to get a discount. And for example, there's what we call a large entity. That's an undiscounted entity. And that's usually, a company that has more than, I believe it's 550. I'm blanking. 500. Yeah, that's right. 500 employees, so, and I don't know about you, but I don't know many startups that have 500 employees right off the bat. So then you have what they call a small entity, right? And that's entitles you to a significant reduction in fees. So, and I believe, and I want to make sure I have this correct, but I believe it's a 60% discount. And then further to that, these are just, when I say fees, they're not just, on the filing fees, but they're also on the examination fees, then they're also on the issue fees later through the process, the grant fees. And so you talk about those savings, they add up. But then even beyond that, when you're talking about the individual entrepreneur, there's also micro entity fees. Now, micro entity fees are reserved for if you're a educational institution, or you qualify on a gross income basis, and there's certain other qualifications where you haven't filed more than 4 applications. But, that's even more discounted. So that can be up to, and I want to say this correctly, I believe it's 70 or 80%. 80%, right. And so when you're thinking about, let's say, a provisional application for a microentity could be as little as nearly $80 or $90, right? That's a filing fee. That's significantly better than what you pay normally. And then when you think about a non-provisional, that's a couple $100 savings right then and there. And the thing to remember is an application, let's say a non-provisional application, it's not even picked up by the USPTO, absent certain ways you can expedite it. They don't pick it up for 3 to 4 years, right? So, you're going to invest not only to prepare this application, but then you're thinking about, I'm going to file it and I'm not going to see anything or any ROI for at least 3-4 years. And even then it's still a process to get it through, right? So I think it's important to think about, we talk about cost savings and, you're thinking about a business or startup that's starting early on, you want to reduce the fees up front as much as you can, right? Because later on, when business is good, yes, it'll be easier to swallow and you'll be able to say, all right, I want to put more money into the R&D, and you'll file other patent applications, right? Because you're going to say, all right, here's my product line. But early on, it's important to be able to have that cost savings. I think, there's the USPTO recognizes that, and even more recently, they've instituted certain things where they're trying to encourage, entrepreneurship or individual inventors by reducing the fees or making further reductions, just so, it's kind of an insight or an inlet into the process. Because once you get into the process, the hardest part is getting into the process for many, individual inventors.
Yeah. So, I want to hammer it home just a little bit, because it's a little bit abstract, but I believe the government charge for a large entity, the normal charge for a provisional patent application is about $300. So it's not really particularly expensive. If you're hiring a lawyer, it's going to be de minimis, but nonetheless, and it's kind of funny. I could hear you struggling to remember the percentages. They used to be so easy to remember until they changed the law just a few months ago. But it used to be 50 and 75%, and basically they moved them up to 60 and 80. So small entity gets half of that, and is going to pay half of that $300, so 150. Micro entity is going to pay, or less than half. I'm sorry. So they're going to pay 40%, right? So it's going to be even less. So maybe it's 120. And micro entity is like 60 or something like that. When you talk about the full patent application, what we're referring to as a non-provisional patent application, which you're eventually going to do, assuming you file a provisional, or you're going to do now if you're ready to, those costs are closer to about $1,000 up front in terms of the government fees. So then when you're talking about paying $400 or $200, versus $1,000, it's a really significant savings. As you also stated, right, that travels with you throughout the process. So when the patent's ultimately issued, those fees are also reduced. So it really does end up being thousands of dollars in the end. So I think that's really important to kind of hammer home that those charges are not that expensive. And I think it's that reason, for that reason, that there are these entities out there that are like, oh, we'll file your patent for you. You can go to these websites and, they'll help you file your patent application, but they really don't give you advantage in terms of strategic planning to ensure that you ultimately will get that patent. It's more like, yeah, you want me to file this for you? Sure, I'll file this for you. I can't promise you it's worth anything, but I'm going to file it. And so there's that aspect too. And that's sort of the reason why you spend money on an attorney. Because if you only have to pay, $60 to file a provisional application, well, I could just file this piece of paper. Nobody's going to look at it, right?
Right.
Sometimes that's even what people do, right? Tell us a little bit about that when it's advisable for a client to sort of file what you call a cover sheet provisional patent application.
Right. So there's times when, and we've had like clients, and I've had, in the past, where they're about to, let's say, discuss something at a convention, right? Or they're about to release something, and it's, it's a big, trade convention, or it's going to be a medical convention, and a doctor's going to talk about, let's say, their medical device, right? And, on short notice, they're not sure if they're going to, pursue, let's say, ultimate patent protection on it, but it is something that's novel, and novel enough that they're going to be the ones, introducing it at their, keynote speaking event. We call it's a cover sheet provisional. Now, what it does is it's essentially, it's a write-up. It's quick. So, the inventor will provide us with the drawings they have in a rough format, a write-up, and we'll try to format it. And essentially, sometimes it could be a 2-pager, 3-pager, but it describes what the invention is, right? And it's important to do that because, we talked about priority date, right? And so, when you file a provisional application, it's a slide scale on how much detail you want in there or have to have in there, but you want to have enough to show that you have essentially possession of the invention, right? So that if someone in the art, reads that, they'll be able to understand the invention and say, okay, I understand the conception, how it works. And we call it like the best mode, right? And so it's important to have enough description there because when you do ultimately file that non-provisional, and it's important to keep in mind, a great provisional application is great, but it's only as good as the detail within it later on, right? So when you file that non-provisional, you need to be able to relate back to that priority date and say, this is the invention, I talked about it here, and this is my more formal, detailed product or description that just builds on that, right? Because at the end of the day, you can only claim priority to that which you have or have shown possession of in the past. And so, these cover sheet provisionals, although quick and dirty, and they're, in an attempt to, just to make sure, again, this goes back to the absolute novelty, you want to have something on file before you speak, if you're considering other jurisdictions. And it's advisable, obviously, in the US as well, but, there is a grace period. But again, the devil is always in the details with the grace period, you don't want to ever rely on that, preferably. So it's important to think about, you do that cover sheet provisional, and we've had certain things where you can daisy chain a series of provisionals, right? And so you may have different stages where you say, all right, I'm building on, this is my first provisional, and 3 months later you say, well, we're in advanced stages, let's do another provisional. And you can claim priority to both as long as, it's within 1 year of the earliest, date. So for example, if you filed a provisional application on January 1st, filed a provisional application on February 1st, then the following year, if you say, I'm going to file it January 15th, you won't be able to claim priority to that January 1st one, but you'll be able to claim priority to the second provisional. So, it's important to keep in mind why you may want to do that provisional application or subsequent one. And we touched on a little bit, part of it is because you're shopping the product. You're looking to license it out. You're still thinking about, all right, I may want to get other funding, right? So we talk about costs early on. So one of the ways, you always see certain shows that talk about pitches, an eccentric owner of the Mavericks is on there, but, they talk about the importance of having that provisional application on file, right? Because you want to be able to build on that later. And, when the money is, you have to be more careful in the early stages of the startup. You have to allocate and prioritize. But if you have a better provisional application or the more detail you have in it, that's going to be something that's going to, help you sometimes get additional funding. So you want to think about how much you include in there, but there's different ways of, how much detail you put, provisional versus non-provisional. And the other thing to keep in mind is the more detail you put into the provisional, in theory, less work is needed in the non-provisional application, right? Because at the end of the day, the non-provisional is going to be what's going to be guiding you into, let's say, that's what's going to be reviewed, that's what's going to be examined. So yeah, but those are the things you consider when talking about a provisional and non-provisional.
So we're going to go to a break, but before we do, I wonder if you could just sort of give a real ballpark, rough range of what you think, in a typical situation. Nobody's going to hold you to it. In a typical situation, how much somebody might spend on the attorney and on the government in terms of filing, from the cheapest cover sheet provisional to the most complete non-provisional full patent application, just the filing, but the preparation and filing. What's kind of the range that people should expect?
So I would say it can vary between 1,500 to 2,000, all the way up until it could be up to 18 to 20,000. And I say that because certain applications may have certain, descriptions that may even be more robust or require even more detail. And so, along the way, you may say, all right, there's more involved. And so the subject matter can really, really shift that. But it can be as low as 1,500. And that's, again, for the provisional application, all the way up until we say at least 20,000 plus, for the non-provisional application.
Yeah, and I think it's also a function of maybe how organized and clear the client is in providing you the information, right? The more you have to spend attorney time trying to organize stuff and put it in the right places and whatever, you don't have things, you have to go back and forth, right? The more time it takes, the more costs there are. So that's great. We're going to go to break. I really appreciate it. When we come back, we are going to talk a little bit about the foreign rights. You've been listening to Intangify on talkradio.nyc. I'm your host, Matthew Asbell. My guest is Chintan Desai, and we'll be right back.
Hey everybody, it's Tommy D, the nonprofit sector connector, coming at you from my attic. Each week here on talkradio.nyc, I host a program, Philanthropy in Focus. Nonprofits impact us each and every day, and it's my focus to help them amplify their message and tell their story. Listen each week at 10 a.m. Eastern Standard Time until 11 a.m. Eastern Standard Time, right here on talkradio.nyc.
In a post-COVID world, you may have many unanswered questions regarding your health. Are you looking to live a healthier lifestyle? Do you have a desire to learn more about mental health and enhance your quality of life? Or do you just want to participate in self-understanding and awareness? I'm Frank R. Harrison, host of Frank About Health, and each Thursday, I will tackle these questions and work to enlighten you. Tune in every Thursday at 5 p.m. on talkradio.nyc, and I will be frank about health to advocate for all of us.
Are you a conscious co-creator? Are you on a quest to raise your vibration and your consciousness? I'm Sam Leibowitz, your conscious consultant, and on my show, The Conscious Consultant Hour, Awakening Humanity, we will touch upon all these topics and more. Listen live at our new time on Thursdays at 12 noon Eastern Time. That's The Conscious Consultant Hour, Awakening Humanity, Thursdays 12 noon on talkradio.nyc.
You're listening to Talk Radio NYC at www.talkradio.nyc. Now broadcasting 24 hours a day.
Welcome back to Intangify on talkradio.nyc. I'm your host, Matthew Asbell. My guest is Chintan Desai, and we are talking about patents for entrepreneurs. We were exploring all different aspects of provisional and non-provisional utility patents. We also talked about design patents. We talked about the fees involved in trying to obtain these and why these are valuable, both in terms of getting them at the end, but also in just getting on file. One of the things that you mentioned, Chintan, in that context is, there's no grace period in many countries abroad, and maybe your invention is going to be something that's going to be offered or sold or manufactured in other countries. So there might be a need to deal with the patent rights in other countries. That might be not something that resonates with people so quickly. We in the U.S. are often very, U.S. centric in our focus and tend to think, oh, well, let's get the rights here. That's all we're going to do. But if I've got an innovation that I'm planning to manufacture, sell, abroad, what do I need to think about and when?
Yeah, so I think it's really important. I think it's often undersold and underappreciated as to why it's important to think about that. And it's important to think about it early on because, like we mentioned, all the costs don't have to be upfront, but you also want to make sure that you don't preclude yourself from, being able to file, let's say, in other jurisdictions later on down the line. And, the the reason is that, patent rights, they're territorial, right? So they're going to be where you file is where you're going to get the protection, right? And that's going to be the importing or where you're manufacturing. So at an early stage, it's important to think about, where do you see the product going, right? Is this business going to be, are you going to be just in the US only? Or, do you foresee it to be in other countries, whether it be in regions, so Europe, but in certain aspects, like if you have specific countries like Australia, New Zealand, China, Japan, South Korea, Brazil, Mexico, Canada, it's important to think about this at an early stage because, and just like you would with your business, right? We live in a global world. So in the business side, you're going to think about, all right, what other countries am I going to work in, right? Or, will this product expand? And, so it's important to early on, incorporate that in your filing strategy because, as we discussed about the novelty, absolute novelty, or certain jurisdictions have different, views on, what's considered disclosure. You want to have something on file and something on file that you can relate back to, right? So we talked about provisionals and the ability for a non-provisional to relate back to a provisional. Well, there's also an international application, which is called a PCT application. I sometimes call it a hybrid, provisional application because similar to a provisional, it doesn't by itself mature into a patent. But it does have some limited examination. It does get published. And it does have certain dates where you have to then claim priority to it into various countries, right? So if a inventor comes to us and says, well, I'm interested in 3 to 4 countries, right? Sometimes this is one of the best options because it's a international application that gives you essentially that placeholder we discussed. And it gives you a preliminary examination, right? And so it's not binding on, the search authorities, but these examinations are conducted by the various jurisdictions' actual patent offices. So, if you have, for example, the US as the search agency, when you do enter what we call the national states, so that's, like in a provisional, you have to eventually file a non-provisional. With a PCT, you eventually have to file a national application, which is just a non-provisional in a particular country. If that country says, well, yeah, you used, let's say, the US search agency for your international application, they may be more likely or more persuaded to follow that when you talk about examination of that non-provisional within their, within that specific country. So it's important on different levels, and it allows you to cut, push costs further down, at the end of the day, because in an international application, you have 30 months, sometimes 31 months, usually 30 months from the priority date, which is the earliest priority date, to file a non-provisional. Now, 30 months, that's quite a bit of time, and that allows you flexibility on the business side to either, have funding or see where the product is going, but also on the, just if you're on the R&D side, determining, do we want to proceed with this? Do we want to push this further? And further to complicate it further, I think, if you think about it, you can actually file a provisional application and then a PCT or an international application claiming priority to that provisional application. And that's going to allow you to, essentially do the same things we discussed, but maximize the amount of time before you have to make the decision on which countries you want to do. And it's important to think about that because if you file, let's say, example, a non-provisional application in the US, but then later decide, oh, I want to get protection in another country, if you don't do it within a certain period of time, you will be precluded from doing that because, once it's published, in the US, or once it's out, once it's like part of an application, you have a certain period of time which to claim priority in other countries. So you want to think about this at an early stage, but you don't necessarily have to, just because thinking about it in an early stage doesn't necessarily translate to you have to put all the costs down at an early stage.
So I think about these sort of the foreign rights aspects kind of like the same way when you go to college, you have to pick a major. You have to pick a major in college, and sometimes people go to college and they don't know who they are, what they want to do. They pick a major, because they need to, or they punt, as far down. They wait as long as they can before they have to. But other people kind of know, this is what I went to college for. And I think if that translates to oh, I know I want to be in the United States. I know I'm going to be in Canada, Mexico, and the United Kingdom. Those are my targets. Yes, maybe there's others, but those are the ones I want. You could pursue those right from the get-go, nice early on. But if you're more like that first person who's like, oh, I don't know, well, I got to feel it all out, see how well it does, see how the funding goes, how my sales are in the US, whatever it is, before I worry about, world domination. And I don't know which country is better for me. Maybe I should pick Colombia, maybe I should pick Brazil, and maybe I should pick China. I'm worried about 1, 2, 3, whatever. So instead, I'm going to do this international application, and then I can buy a lot of time, and then I can deal with deciding the countries down the line after I know how it's going. Yeah. That makes a lot of sense, and it could save a lot of money for an entrepreneur. They're not free of having to pay anything, right? By deferring this cost. There's going to be a fee in that early stage to do the PCT application.
Correct, and it is definitely more than the cost of a provisional application. But as we discussed, the benefit is you do get insight into examination, right? So provisional application doesn't get examined. PCT does get examined, but it doesn't mature into a patent. But that examination will give you insight into how other countries will treat it. So you may end up at that stage and say, well, I don't know if we want to do this. And it's kind of important because it gives you all the tools to decide when you want to incur those costs, right? And so that's just another tool to kind of give you the insight into what the future looks like, because ultimately it is a business decision, right? And it's going to be where the product takes the company. And I always say this, the IP should not drive the business should drive the IP at the end of the day, right? So that's kind of the core thing where they work with each other, but the IP is supposed to complement the business and help the business get to its goals.
That's great. Thank you so much. We're about to end, but I wanted to ask you to, leave, what your main message would be for the entrepreneurs listening to the program. I'm an entrepreneur. I don't know anything about patents. What's your message? What's your message for me?
So I would say identify some of these ideas early on, right? Just like you would do in business. If you think this is a niche, this is something that no one else is doing, and this is why my product is better, identify that and keep it close, keep it close to the vest in the sense of take adequate protections before you disclose it to others, right? And that could be, we didn't get into it as much, but having a non-disclosure agreement, making sure it's kept under wraps, because at the end of the day, you want to make sure it's protected, but then also filing those provisional applications or those other aspects to protect it early on, because once it's out there, you want to be able to claim the earliest priority date and, be able to then relate back to that and build upon it at a later date, or sell it or license it, and be able to say patent pending, right? So I think in the course of business, it's important to identify those things early on and to make sure you protect them. And then, and it you shouldn't be bogged down necessarily in the costs, because like we discussed, there's ways to kind of prioritize certain costs, or there's ways to delay certain costs, right? While you're trying to determine if this is the product for me. And so I think just like, an individual's branding or a company's branding, it's important to control that message or shape that message and protect that message before it's disseminated to the public. And, it's just like anything else. You want to be able to guide that, because that's, what your sweat and tears are going into this startup. That's what you're thinking about, right? Because I know when I talk to inventors, they know it, inside and out. They know their invention, right? And I think that's one of the most fascinating things when you talk to an inventor. You have to learn their, what the invention is, be able to speak to them about it, and then translate to the legalese and of the patent applications. But I think it's important because you live and breathe this invention, so it's important to protect it because you spent time and money into this, and time and sweat equity, And so I think that's probably the takeaway, embrace it, kind of identify it, and then, don't hesitate to, pursue or get advice, because, it shouldn't be about cost, because there's ways, like I said, to, mitigate some of those risks.
That's great. Thank you so much, Chintan. My guest has been Chintan Desai, an attorney in intellectual property and patent law at the law firm of Offit Kerman. Pleasure having you. You've been listening to Intangify. I'm your host, Matthew Asbell. Please tune in on Fridays at noon Eastern time for our podcast. Thank you so much. Have a great day.